Very
Yeah.
happy to have you.
Thank you. Okay, thank you very much. Okay, so yeah, we're kind of debating what to talk about, here, tell you what I've been up to since when I left in 2016 or so. Whether to do technical stuff, not technical stuff. So this talk is, the in terms of the technical algorithmic innovations is not very strong, but it's strong in other ways. I think would be of somewhat broad appeal. So I don't know if everybody here, the computer scientists, the people not computer scientists, but the talk is meant to be accessible to non-computer scientists as well, which is a challenge, by the way, to do those talks. Anyway, so can cryptographic algorithms affect legal doctrines? And this is based mainly on two works, which are joined with law professors and computer scientists, trying to impact law using computer science and cryptography. So the social contract, as we know, is something that we all are kind of abiding to every day. So we know that living in society, it's a great benefit to everybody. If each one of us want to live where to live on their own, we're much worse off in the woods. But it really involves a lot of compromises every day because we live in society, and particularly, many of those compromises, if you think about it, the liberty of one versus the liberty of another, or the liberty of one versus the physical harm for another, or physical harm versus well-being of another, etc., etc. And we have to balance them, harming one group with harming another group, and we can all continue on our own with this. And the point is, though, that there's no set of decision rules that is going to be completely universal and acceptable to all, right? It's kind of like inherent. Because we come from with different philosophical backgrounds, religious backgrounds, historical, pragmatic characters, etc. So we have to accept the fact that there is no one rule that everybody accepts, and there's no such thing as ultimate one perfect justice and equality, etc. But anyway, we engineered a legal system that still allows us to coexist together, right? And this is something that we all based on, kind of the foundations of society in some sense. The point is that this legal contract, the social contract, where the social contract is like actually a very famous work by Descartes, and these guys are Hobbes and Locke, two philosophers, kind of opposing philosophers about how to think about society and people in society, etc. Many others. So the social contract is evolving, right? Because society changes, the makeup of society changes, technology changes, and we have new solutions, new opportunities, new harms, new power relations, things change all the time, the dangers, and we know that technology affects the social contract, not always for the better. Think of all the technological inventions over the centuries. So they change society, change the contract between individuals and society. And the legal system is built actually to accommodate this evolving contract, and it has to be, right? So in particular, there's legal philosophy and legal doctrines, and there's the statutes or the laws that are usually written or ideally written in this principle technology agnostic ways. What is right and what is wrong, and how should we think about things. And then there are lower-level things such as regulations or the common law in common law-based countries, which is Israel is actually part of them, US, England, that actually adapt the statute, the interpretation of the statutes to the current technology. Or so we think, and this is ideally the case, and the point, it doesn't always work this way. And when talked about an example where it doesn't work this way and propose a solution, technology can actually propose a solution that affects, goes upstream and affects the legal thinking, the legal doctrines, potentially, hopefully. So in particular, talk about the case of data disclosure harms. So there's, of course, it's a whole broad, world of data disclosure harms, and I'm not going to talk about things like data aggregation, differential privacy, or privacy in general, and used to that. It's a very respectable area, of course, that there's a lot of work to be done there, and actually to affect legal thinking there, from technology, and that's kind of future work. That's not what I'm talking about. I'm talking about more about specific harms from data disclosure in legal disputes, right? So we all know, regardless of data, that resolving legal disputes is first inherently imperfect, and second, it's costly, and it's costly to many different constituents, right? This is costly to the parties, so to the litigating sides, and it is costly to the system. The administrative cost is high. And also there is this imperfection in outcome is costly. It's costly in first injustice, in public trust. There's a kind of evolving harm from legal system not working perfectly, or not being trusted. So balancing all these costs is crucial for a workable legal system, and we kind of always have it in the back of our minds, but we don't always maybe say it explicitly. And in particular, talking about again the data disclosure harms, is what about the case about the harms that result from data disclosure, right? Inadvertent or necessary, whatever. So let's say within the legal process. So it is not always something that that's kind of commensurate to the actual legal dispute. It's not always something that is easy to measure, to predict, and it's not really addressed in an explicit way. Sometimes it is, and somehow it's treated inevitable, right? And this is, of course, where we are trying to go against, but just to describe what is there today. So there's the recurring dilemma, of course, in legal disputes. In general, should we disclose data or not? And there, if you go over, different cases in the body of law, and have different, you see many examples. Actually, the first paper that is this work is based on is actually does that. It's goes over different cases over the legal literature and identifies places where there's actually such dilemmas that affect the law or the outcome, whether to disclose something or not. So let me just say, very quickly, I don't want to spend a lot of time on it. I want to talk about one of them, but a lot, but let me just mention them. So mergers and acquisitions is one place. It's kind of obvious place. So you're a company, you want to be acquired, or you want to get funding. So you want to disclose your finances or your whatever your assets, and then. But then the entity that may buy you may actually be a competitor in the future, and then what do you do with the data, right? With this factor disclosed. In fact, here this is a specific case of some target smart wanted to be bought, and this catalyst, representative catalyst, came and sold the data, and then apparently it was just according to target smart was a scam. And then they use the data against them, and it's litigation that goes on. It's further now, still going on for like 6 to 7 years, and it's not clear where it's going to go. But again, just show you the problem here. Trade secret litigation is another classic example where the disclosing the secrets they're litigating on just obviates the whole case, and sometimes this is a strategy of lawyers to how to kind of like call it gray mail or extract money from companies. So this is a famous case of the Coca-Cola bottling company sued the Coca-Cola company, something never mind the story, but the point was that in order to decide, the judge ordered Coca-Cola to disclose its secret recipe for the drink, and of course Coca-Cola settled in a very unfavorable way just not to do that. And again, the legal system doesn't offer any remedy or any solution to that. The issue of transparency versus secrecy of regulatory actions. So this is famous stress test you do to banks in order to show the viability after the federal law after 2008 downfall, and requires a lot of people who actually have hats of both federal and banks to actually keep secrets from each other and from the public. And there's been at least one whistleblower case which actually argued this is a whole scam, and we don't have any way to know because it has to be secret because whatever. So yeah.
It's M&A, isn't that why we have intermediaries? Investment banks.
Yeah, so there could be intermediaries. Here they don't have intermediaries. Well, actually, here in the specific case, I'll get to intermediaries.
M&A case. Investment banks usually.
Oh, M&A, right. So well, sometimes you don't have it. Well, actually, this is the case. You want to get somebody bought. Somebody buys you, right? So I want to buy. So they want to see what they're buying, and
I thought that usually the investment bank is doing that due diligence and shouldn't go back, but maybe in this case.
In that case, they did it. Okay, but I think the assets involved with actually lists of potential customers or buyers or something. So they won't, but you can do that. But again, so there's the issue of you can have a trusted intermediary, and I'll get to that. In the example I'm talking about, it's not always it's when it can be done, but it's possibly it's imperfect, etc. Yeah, but here this doesn't really help you because you need transparency, right? You need if an expert tells you it's okay, and the expert would be a financial person, then what does it really mean, right? To the public. But so there's the issue, right? But yeah, so. And in another case, the fourth case, we actually want to concentrate for the rest of the talk, is what's called law enforcement evidentiary privilege in criminal prosecution. And we'll talk more about it. So actually, let me say, so this is something that has a long history. So this is not something that a lawyer co-author found this. So this is the Bishop of Atterbury, I think, that in 1711 or something was tried for treason, and he was jailed in the Tower of London. And they had some evidence, not exactly then, but then there was a letter that he wrote to somebody from the Tower of London, somebody outside, and it was encrypted, and they managed to find an expert that decrypted it, and the decryption actually was explicit that this was a treason, and that was execution worthy treason, and there was a trial, and the bishop or the solicitor of the bishop wanted to see the evidence of how it was decrypted, what was the ciphertext, the plaintext, and of course the defense says that it cannot be done because that will actually disclose and allow many other people to evade and decide this is an impartial witness. How do you suspect it? And the court accepted it, and the person was convicted and executed without seeing the witness. Okay, so that's one thing. Okay, fast forward 1960s. I don't know if any of you were alive there. Then I think 1961 and 62. Remember so this is the Copeland couple that were arrested and jailed and prosecuted for spying for Russia in the U.S. And there was tons of evidence against them, but the FBI wanted to keep the evidence secret. And now, how do I want to read from the thing? Just a second. Okay, so but then there was a judge. The judge actually, the name of the judge was Learned Hand, and he said something like this, that it is inconceivable the prosecution cannot conceal information from the defense while simultaneously seeking to rely on the very same privileged information to support its case. And it actually really said, I called it a mistrial, and they were free, right? So this is the opposite extreme. And the thing is that this issue continues today, and it really continues today to these days. And in one place to do it is in a slightly different scenario, but so here's just it's not a lot of information here. So it's about people who are viewing illegal photos, child porn photos, which are in the US. It's illegal to possess them in any way or form. It's one of the few things, maybe the only thing that is just illegal to possess unless you are privileged. Law enforcement, even law enforcement cannot do it unless they're privileged. But people still share it, and they share it over these peer-to-peer networks. So let me just remind you how these things work. So it's a network of computers, people's users that they share files directly with no central server, and each file is actually split among multiple computer users, and when you want to download the file from the system, you collect the pieces from different users, and you also share pieces of the file that you have to different users. And there is a fancy hashing way to do it, and it's more robust, enhances privacy, but unfortunately also helpful for sharing illegal materials, such as this CSAM is the term for child porn pictures. And apparently it's a very big market in the US, lots of how many millions of 10 or hundreds of millions of dollars. And it's an industry because there's so much money, those things actually being done to children in order to support. So it's really bad situation, and we all want it to stop, right? So there's a clear incentive to catch those people who distribute and shared by CSAM on the internet. So the way the law enforcement does it, it's actually, well, in order to prosecute somebody, it needs to evidence that the person actually had a complete file. So it has to find, it has to get the entire picture from a single source, from the suspect, in order to show that they actually had it. Just a piece is not enough. And so that means it cannot use the same software, because the software wouldn't do that. So it actually has to modify it and play with it and tinker with it to do things in order to get evidence, right? This is something that law enforcement does. It's okay, it's good. But the question is now, what happens after this happens, that now it comes to court, right? And now the defendant wants to see the evidence against them. So let me just tell you two cases. One of the things I've been reading hundreds of pages of legal documents. Those lawyers are amazing. I get tired so fast. But anyway, so this is one case, the U.S. versus Budziak, this person. FBI uses a modified version of this LimeWire peer-to-peer system in order to get evidence that the person actually sent files to a law enforcement user, pretending to be a user. The defendant stated that they consider the file to be unshareable. So actually there's different levels. If you just have it, that's maybe 5 years in jail. And if you actually distribute it, that's a 20-year in jail. So it's a big difference. So said the alchemists kept it for themselves. It wasn't set for distributing, and they don't know the software messed it up with their computer. They set the bit for sharing themselves. It's not him. He wants to see the software, and he wants to see that he didn't tinker with his computer. And in fact, there was actually some supporting evidence, because recently, slightly before this event happened, there was actually some virus that was going around, and this virus, or this hack, was actually surreptitiously turning users' share bit on computers, because it was actually good for the sharing company to people who share. So it was, I don't know if this is the because, but it just was just there. And the question actually of the defendant was very specific. He wanted to know if the law enforcement software, modified software, when they forked it from the public file, was it forked before or after the protection against this particular hack was done, right? Very, very reasonable, right? But the judge accepted the law enforcement claim for evidentiary exception, privilege, and continue to trial. This is all in the evidence before the trial. They continue to trial. The person was found guilty, sent to court, sent to jail. Then they appealed, and then the Ninth Circuit actually remanded, which means sent it back to the courts, and said that actually the defendant should be able to see the evidence. And actually, they were quoting some specific, previous rulings. So a party seeking to impeach the reliability of computer evidence should have sufficient opportunity to ascertain pre-trial discovery whether both the machine and the way that it was used was done well. And then even more, that it's quite incomprehensible that the prosecution to attend their witness to state the results of computer's operations without having the program available for the defense scrutiny and use on cross-examination if desired, right? So they send it back, and then they ask the FBI, sorry, you have to show the software. And then actually FBI were unable to locate the software because they said it was written by a contractor and it wasn't already there. But anyways, the case was dismissed. The person was released from jail. Right, so the system failed on many different levels. Right, trust in the system. It's not what's going on here. Right, here's another case. So this is the counterpart review. Another defendant, Clement. So again, same story. Now the FBI, instead of writing this peer-to-peer hack themselves, they actually went to an external vendor and bought it from an external vendor, because again, because it's not clear there's a because here, but external vendors are under less scrutiny. It's harder for a judge to force the external vendor to disclose their software. And in that case, the files that were downloaded were the only evidence. Before, there were other evidence after they searched, but now it was the only evidence. But now the two sides agreed for compromise to go to an expert, right? To agreed expert, and it was hard to find an agreed expert that both the FBI and the defense trusted, and agreed that they would do it on the FBI ground in a specific way. They agreed on a protocol, and they agreed on a set of questions, which I'll talk to you in a second about. And then the defense experts came up with a decision that actually completely sided with law enforcement. And it turned out, when in the report of the expert, that actually they didn't go through the protocol, the agreed protocol. The expert was supposed to see the source code. They did not see the source code. Was not allowed to see source. It was just allowed to run it. Or maybe the other way is wrong. We saw the source code, but wasn't allowed to run it on test cases. Anyway, in the conclusion of the evidence of the expert, was clear that he could not have reached the conclusions that they reached in the response, right? So, but then the judge at this point was tired of the whole thing, said, okay, let's continue to court. And again, the person was found guilty and he's in jail until now, at least, right? So again, it's not clear. And even the point here that even when you have an expert, it's not clear what the expert is supposed to do, and it doesn't necessarily create trust, because the questions, and here the question that you ask the expert, right? So there were, here are the three questions that were asked. In fact, you can think of it technically. The technical questions is, did the software really get all the pieces of the file from the target computer, right? So that's what the defense wanted to know, or from other places. And second is, does the software have the capability to change sharing permissions on the target computer, right? But when you translate to legalese, this is the interface with the expert, so these are three assertions that the expert is supposed to say yes or no about, right? So the law enforcement software does not exploit the vulnerability of any software. What it means, obviously, whatever. Yeah, so it's not really what you want, right? And the law enforcement software does not misuse protocols on the P2P network. So it's very vague, and it's not clear how to interpret it, and etc. So let me not bore you with details, but the point is that a lot is lost in translation, and it seems to be inherent in the system. But anyway, so the common wisdom and all those things that either you expose information or you lose trust, and the common wisdom is in all the things that to prove a point you need to disclose relevant information, and the more information you disclose, the more trust you get, and that's essentially the only way to gain trust. But then, of course, you are exposed to extraneous harms, which here law enforcement, maybe the software is going to be revealed, and other people will be easier for them to evade. So the belief is the trade-off. It's inherent. So the economics, there is, the point is that it's inherent. And what we want to do here, and I think it's probably obvious to people in the room already, that we want to challenge the wisdom that it is possible to regain trust with minimal exposure of sensitive information. And in fact, by using the right technology, you can have a rich surface of decisions of which information to disclose and which not, and gain different levels of trust and social benefits from these, right? So it's not just disclose or not disclose. And the main tool, of course, is that we're going to use here is zero-knowledge proofs. So I have a story here that explains zero-knowledge proofs. I don't know if people know, but I think it's a nice story. Just if you want to explain zero-knowledge to somebody. So here's here's an idea of zero-knowledge, maybe the least technical way that I could think of. So assume that you are, you walk with your friend in the forest, and your friend tells you, I take one look at the tree and I can tell you exactly how many leaves the tree has, right? Okay, so how do you verify that this friend is not lying? Well, so we can do actually a nice interactive proof for this. So what you really, so we can actually ask them, so how many leaves are there on that tree? And you get a number, 145,679. And then what you do, you say, okay, you just pick a random batch of, batch of leaves, and a random number, small number of leaves in your hand, and you don't show it to the friend, and you ask, okay, so how many leaves are there now? And they give you another number, and then you can subtract and tell for yourself, right? So this is a nice interactive proof for proving or verifying ability to counting trees, leaves on trees, right? But then how do you make it zero knowledge, right? So now you are the person who knows to count leaves on trees, actually, but you don't want to tell the other person how many leaves are on any particular tree, but you want to still prove to them that you know how to count leaves on trees, right? So now let's just tweak this thing a little bit. So again, so now I'm the friend. I know how to count leaves on trees, and then my friend asked me, yeah, so how many leaves are there on that particular tree? And then I count, but I'm not going to tell you. But now, when you please take a random number of leaves in your hand, and I will tell you how many you have in your hand, right? And I can do that because I can subtract, right? But the person did not learn anything except for how many leaves they have in their hands, which is they could do themselves, right? Which is the notion of zero knowledge, right? You don't tell them anything more than they compute themselves, other than the fact that you know it too, right? So this is yeah. So this is the idea, right? But this is a nice story. But now, how to make it digital? So this is the story that I'm sure all of us know. So but actually, let me say something here because that's actually important. So what is the public and what is secret? So there should be, if you want to apply it to legal digital information, and that is also legally relevant, then it has to be some public data that everybody agrees on, and which we can be commitment or encrypting or something of some secret information. And the verifier has the public data, and he wants to verify the prover has some secret S that satisfies some check program with the public information. And this can be anything, right? So it can be formality, and I know how to factor this large number, or more pertinently to us, it can be the data can be a commitment or encryption of some public information, of some secret information, and then the proof will say, now I know a decommitment to that, and that decommitment has all these properties, right? And that would actually go back to what we have there, right? You already had in the court system. So there should be a public commitment to secret data, and then proofs on properties of this data. So this is different things, and we'll do that. So this is your knowledge, and we know that there's a mathematical definition that we all know and love. Never mind that, and we can construct it both with an interactive protocol, also non-interactively, just one message, and we can do it for any predicate. And these days we can do it for any predicate kind of like efficiently, not even the proof is succinct, and the verifier works for a little time, and the prover works time, which is not much bigger more than they would need in order to just verify the random verification algorithm themselves. So this is really something that, in terms of technological feasibility, is readily available, but even used in practice. So now how do we use it in the legal system? So there's a one-liner here. Just have them prove it in zero knowledge, right? And story, and we're done. But and in some sense, this is all there is to it. But the question is how to make it work and how to actually connect it with the legal framework and actually have the courts and the lawyers and everything accept it and take it and potentially use it. So there are challenges, right? So first you have to explain the idea to legal audience, what this zero knowledge thing mean, and actually the stories or leads can be useful here. We can actually explain it in a more detailed level. And then there is also more pertinent questions. What is the public input? What is the witness? Who gets to decide? Who can decide to the predicate? Right, and because we are in a legal system and legal, in a court case and very adversarial setting, which is, we have to decide of things. Actually, it's a good exercise because some sense zero knowledge should be able to apply here. And then, of course, how to connect the legal information, the evidence, to digital information. And that's why this peer-to-peer cases actually are good, because the information is digital to begin with. Okay, so here's the workflow that we proposed for this specific case of law enforcement privilege in a legal in a criminal persecution, right? So here is the kind of the four-step legal flow. So first there is the claims. There is the prosecution that has claims. Sorry, this is whatever. So there is a claims that relate to some secret object X, which is in our case, the example is this law enforcement software that we're running. And let's assume it's a text file, which still can be a software. And what we do? So first we have a check program that checks properties of X, right? If X is a program that does the program ever turn up the share bit in the target computer? Can it do those things? In fact, can it do send any messages which are not legal messages in the protocol that it is running? Does the software correctly record all the data that it received from the target computer in order to show that really all the shares came from that particular computer as opposed to different computers, right? And questions like that. So these are properties that we can check. And this check program is something that, you know, the prosecution would necessarily give it ahead of time. So this is what we want to prove. And then, you know, the defense will accept or not accept. Well, actually, I can get there. Maybe I'm running ahead of myself. We get there. So anyway, this C is the check. It says that the claims are true. And then you write this check in some language that is friendly to zero knowledge proofs, which we have these days. And the statement would be that I know some programs for which this is true. And then the workflow will be the following. So first, you of course the prosecution commits to the program. This can be done actually way ahead of time before the trial. You know, once they have the program that actually run it, you know, at the time of actually running it, they can commit to it. And then later on, then they write the initial check program, and then they're submitting evidence. When law enforcement submits the evidence, which is based on this program X, they actually give a proof of or the design of C and suggest it to the defense or to the court, and then the court and the defense check different properties of this check program C, right? So in particular, the defense wants to say that the claims are really what I want to know in the defense, and the law enforcement want to know that those claims do not actually reveal secret information or too secret of information on the secret, which is the program. So each side has their own requirements on this check program, and then in the end they reach some conclusion, or together maybe with the court, decide what is the check program that is okay and that is going to be acceptable. This is maybe something that can be done with this kind of replacement of the expert witness questions, but now the questions are very specific and very technical, because the expert witness is this program. And then in the end, so there's kind of maybe an iterative process here. And in the end, you actually run the program, and then the court and the verify and the defendant just see that the program, you know, outputs yes or no. So the point is, so this is the system, and then it all boils down to writing down the right check program, right? Which is the right thing. Yes.
Presumably, for the example you gave with the child pornography software, a non-zero knowledge prover could also prove, do static analysis of the program and prove that if the program says yes, then the target file was on the target computer and that it didn't break the protocol.
Right, but I agree you could do it. And not in zero knowledge. Well, the one thing that you don't want, that you need zero knowledge for it, is to prove that when you talk about the data itself, when you get the data from the program, say you get data from different computers, you want to show that this is really combined to a file, and all this comes from guys, and maybe there's other things there in the stream that you got that because you have to show, this is what I got in the stream for that particular point of time, and this. So this is right. Properties of specific program you could do without zero knowledge, except that it may be good to commit to them ahead of time. In fact, this is something that you may want law enforcement to commit ahead of time to a program and prove things even before the trial begins, right? Not whatever. Okay, but yeah, I agree. And there are other issues here, but for instance, who said that the program that law enforcement shows in court and proves things about
that's also in chemical tests in
exactly.
law enforcement,
Exactly.
the record sometimes the trust is warranted, sometimes it's not.
Exactly. And the point is that something that this I learned from the my legal quarters is that you shouldn't expect like a whole complete solution in order to work. It's just even some progress over the state of the art is already a lot.
Yeah, this
right?
is
You cannot don't need to solve everything.
corresponds to a legal acceptance of the accuracy of, let's say, a chemical test of drugs.
For instance, right? Yeah.
There are other issues of whether the test is done properly, whether you trust the tester.
Right. Yeah.
So even if we agree on this program, which is like a very difficult step, can we just like let the judge execute it and just skip the whole zero knowledge thing? Like, would law enforcement object?
So that's okay. So I don't know about the judge, and I don't know if judges. In principle, you could, right? But I think law enforcement is very particular. But I don't know about judges, right? But the law enforcement is really doesn't want anybody to see their things, so they don't trust anybody, right? And even in their own premise, right? To take a program out of their enclave and take it outside is a problem, and also that's one thing. Another thing is that at least in the US, the judges are supposed to be not experts. So it's supposed to be, in fact, all this is happening and before there is even a jury. It's just like in the preliminary state of getting evidence and sorting for evidence. And it's not clear the judges would want to take this, task upon themselves. And in fact, there is another issue which I'll get to in a minute, but hold on to this question. Yeah, but those.
It was roughly the same.
Same thing, right? So here, yeah, you're right. So here you could potentially do that, but again, if you want to actually do things about, there is a lot of information out there, like in the statement that really the files that I got from the system really all come from the same source. You need to show a record of what you got from the system and what part of it came from where. There's a lot of data which is sensitive, and I don't know, there's something that you want judges to look at. Yeah.
But where are you running the program? Because in some sense, it needs to run on something physical.
Right.
And if the
on law enforcement.
No, so I don't, as a defense, you don't want to run on the law enforcement computer.
No, that's the beauty. So the defense only gets a number, and the number, it tells it it can verify the number. Right. That's the right. And there's a commitment to a program, and there's a proof, and they know that this happens no matter how you run it.
Okay.
Yeah. So that's the important thing. Yeah. Okay, so then we actually built such a check program on a toy case just to show that you can do it. So in fact, we've actually structured the program in a specific way, so it would be easy to do those things. Actually, make it even easier to do it, even potentially without zero knowledge. But so we said that the program would be two parts, which is the communicator and the core component. And in some sense, the only thing that you want to verify that has to do with what the defense wants to know has to do with the communicator. So all the defendant wants to know is that it really only talked in a legal way. It didn't send messages which are not legal program messages. And also that the information is stored, only information on the output, the decision to say this guy is, this file actually came wholly from the defendant only is a function of what happens in the communication here, right? So this is here, this communication. And then there's a core component that does all the logic, and this core component doesn't talk to anything else outside other than via this legitimate channels. And then once you assert that the program has this form, then and the community can be public. This is nothing secret here. The only secret to the logic is the core. So you only need to prove things about the core, not about the communicator, which makes life much easier because kind of like sandbox the core in something. And of course, the core can try to do malicious things and jailbreak and do all kinds of repetitious things, but again, again, the answer is that's another level of cheating by law enforcement. Yeah.
You mentioned that you wanted to make sure that the law enforcement program does not change any local configuration on the other side. So this also depends on how the original program runs. In some sense, you need to have complete formal verification of the original software in order to check that no type of communication can alter the configuration.
Right.
So this is not just the scope.
I agree. But again, I agree with you. But I think there's an issue of onus of like flipping the onus of proof, right? So once the law enforcement says, look, all I'm doing is sending formally legal program messages, of the underlying, LimeWire, whatever software. I'm not going beyond that. Then the onus kind of goes back to the defendant to show that even with such things, you can actually maybe do such things, right? You cannot just say maybe, it goes to them, right? So it's a delicate game there, right? But yeah.
I think that maybe this is the same question, but the problem is that you prove that even if you prove this thing, you prove that now you have a software that follows this criteria and does whatever, but it doesn't mean that this is what they actually use. You get the provider, you could have flips this bit with another software.
Completely correct. But but this would actually require more cheating from law enforcement. That's something law enforcement could do potentially if you're completely malicious law enforcement. But
so if the bottom line is that we need to trust the law enforcement to be honest anyway.
But it's different, right? It's different, right? So we know the things work in reality. So people try to do things, and if you need to commit ahead of time and say post your commitments every time, this is the program that I'm using today, and this is I have a set of commitments, a blockchain of commitments. Everything I'm doing, I'm committed to, right? It's secret, nobody knows about it, but it's still committed to later prove things about it. Right, then it makes the bar of cheating much higher, right? So you have to premeditate and maybe, but I want to make there's a point here that there's actually a legal point that I want to get to. After there are lots of issues here, right? And what exactly do you want to prove and stuff? But I think the point is that high level point that you don't need to solve everything in order to make things better, right? So and we're trying to make it as best as we can, and of course it can do better, hopefully. But anyway, so this is what the check to be doing. I said never mind the details here, and so it's not a foolproof. It's not foolproof. It's not completely sandboxing, but would still provide minimal feather of assurance. That's what that's the point. And then also we implemented, not me, but others implemented this. Cairo, maybe you can do it in other languages, but never mind, you can actually do it. And it runs, and it's not so complicated. It can be done. And why is it important that we actually implement it can be done? Never mind exactly the details. Maybe today I wouldn't use Cairo, but never mind. So there are choices and justifications. I think we talked about them. I don't want to spend more time about it. But this is the point I wanted to make. So the very fact that this is feasible and this is doable and this is something that can be done and not at high cost actually has important legal significance. That's what I learned from our lawyer co-authors, because there is a legal process for evaluating when is law enforcement allowed to claim its evidentiary privilege, which means not to disclose things to the defendant. And the point is that First, they went to check whether the requested information is actually material to the defense. But the defendant has to show the information they request is material. It's not just out of the blue, but something. And then they check whether the information can be obtained via alternative means, right? The law enforcement can give the information the defendant wants in alternative means to disclosing. And has law enforcement made reasonable accommodations to make the information as available as possible. And only if law enforcement thinks, defendants to show the first, and the law enforcement has to show, in fact, the defense has to show the first two, that it's material and cannot be obtained in other ways, and then law enforcement has to show three. That's how the court goes. And then only if law enforcement shows three, then they get the privilege, right? So now, given the fact that you can actually, they take technological feasibility and you can actually do it to prove things as your knowledge, then it will be harder for law enforcement to make this claim, right? Because they have to make all reasonable accommodations for the information to the defendant. And I think that's in some sense that's the hook here, is that because it's feasible, actually could change the legal structure and legal balance. And again, those cases keep happening all the time. I mean, I showed the cases I show you, one 2008, one 2015, the later ones, the ones all the time. So hopefully something will be, somebody will pick it up and be used. I don't know. Anyway, so this is the point. So it somehow forces law enforcement to do something about it, as they didn't do before. So anyway, here we say we propose that if law enforcement doesn't use the honest truth, it would be a violation of 3, and therefore they will not have privilege. Okay, so summary. Okay, so those dilemmas are abundant. I talked about several cases. There are many more. And really, you can have there's an opportunity here to make legal processes better, less costly, and actually more nimble, and more just because now we can make decisions about not only whether to disclose or not, but what to disclose and what fractions or what functions of the secret information to disclose or not. And there's a lot of room for play there. So you can have a better balance between disclosure, between verification and secrecy, and law and technology in general. So yeah, it would be nice to find that actually making use in court with your knowledge, and maybe build the toolbox that is more directly specific for these cases. And I think more generally, I think this idea of journalist proofs, it's kind of one of these funny esoteric theory of computation, theory of cryptography, or theory of computation ideas from the 80s that actually today are matured and actually can be used in many places. And I think it would be nice to make it more ubiquitous. People understand the fact that actually, when they want to prove something, they can actually do it in zero knowledge and choose what it is they want to disclose or not. Multi-party computation already kind of found its way into the more mainstream, but I think zero knowledge can too. So that's it.